So hi everyone, welcome to this week's edition of the Summer Speaker Series brought to you by AEI's Academic Programs Department. My name is Luis Perales and I'm very excited to be speaking with Adam White on the Supreme Court in a hyper-partisan era. Now before introducing Adam, I'll mention that the Summer Speaker Series is a chance for members of our student network to stay connected with each other and to take a deeper dive into some of the latest scholarship coming out of AEI during the summer months. We're nearing the end of our summer run, but we'll be hosting two more conversations besides this one next week and one the week after that. So keep an eye on your inbox for those invitations, and be sure to like us and follow us on Facebook and Instagram at AEI for Students to stay abreast in recent conversations and upcoming interviews. Now, our format for today is going to be pretty straightforward. Adam and I will have a conversation for around 20 minutes or so, and then we'll turn to your questions. So if you have any questions for Adam throughout, please type them using the Q&A feature at the bottom of your screen. You don't have to wait until the end of the conversation to do so. You can type those throughout. And I encourage you to use the upvote feature to help us decide which questions you want answered. And we'll try to get to as many of those as we can during the last 10 minutes or so. And with all that said, I'm really excited to introduce today's guest, Adam White, who is a resident scholar here at AEI, where he focuses on American constitutionalism and the Supreme Court. So Adam, thank you so much for joining us.
Well, thanks. It's a pleasure to be here. And thanks to everybody for joining us. I'm really looking forward to the questions.
Absolutely. Now, the Supreme Court term just wrapped up, and like in recent years, it seems that the cases that attracted the most attention from commentators and from the general public, those cases came out over the past few weeks. And I think there's probably this sense that major decisions were being handed down day after day. But you recently wrote a piece for Medium that makes the case that that sentiment might be missing something about the Supreme Court's process for deciding cases. Which necessarily has to take a longer view of things. So can you elaborate a little bit on that? What do we miss when we focus too much on the release of cases and not enough on the process the Supreme Court undergoes?
Yeah, I wrote this casual little piece on Medium over the weekend about the Supreme Court's decisions in some of the religion cases and their relationship to the court's decisions in cases like Bostock, the Civil Rights Act case involving sexual orientation and gender identity. I said that at this time of the year, the way we read Supreme Court opinions is each day that the court announces opinions, a couple of opinions come out and we scurry to read them and we analyze them. And if you're, a partisan or an advocate, or you just have a firm viewpoint on a particular issue, like I often do, you kind of declare victory or defeat for the day. And then you move on. It's kind of like at the end of the day, the casino closes and we pick up our winnings or we suffer our losses, we walk back, and the next day is another day. The point in the Medium piece was that when we slice up the cases like that, we sometimes lose some context. And here's what I mean. A few weeks ago, the Supreme Court issued its decision in the Bostock case, saying that the Civil Rights Act's protection against discrimination on the basis of sex protects employees from discrimination based on sexual orientation or gender identity. The court said in an opinion written by Justice Gorsuch that when an employee suffers discrimination on the basis of sexual orientation or gender identity, it's inextricably tied up with perceptions about sex itself. And so that's discrimination. And so that was hailed as a major victory, particularly among progressives. So there was a lot of concerns among conservatives over that interpretation of the statute. Well, then a few days later, the Supreme Court issued decisions involving the Little Sisters of the Poor, reaffirming the new regulations that exempt them from having to pay for contraceptive coverage for their employees. And there was another case called Our Lady of Guadalupe School that reiterated that religious schools have broad authority to hire or to fire employees in order to preserve their religious mission. And a lot of the criticism of those decisions coming from the left was that the court was rolling back undercutting some of the wins that the left saw itself as getting in the Bostock case. And my point in the opinion was, or the op-ed, the blog post, was the court was thinking about all these cases at the same time, right? The Bostock opinion came out a few days earlier, but these cases were argued long ago. The justices have been deliberating on them, writing their opinions, debating about all these cases all at the same time. And so we really need to think about how these opinions might have colored one another. And the bottom line of that is maybe it was because the court, some of the justices, particularly Gorsuch, since he wrote the Bostock majority, since he knew that the court was going to be taking steps to protect religious liberty, he might have been more comfortable ruling the way he did in the Bostock case, knowing that there is going to be some space for religious organizations to continue to follow their mission, notwithstanding the Bostock case. And so I encourage readers to really think about this. Now, I will say the main line of criticism that I got was that it paints the justices as very political, right? Compromising on principle based on the politics. That's not what I meant. What I meant was that when justices are deciding whether an interpretation of a statute like the Civil Rights Act is reasonable or not, there's all sorts of considerations that come in. And the reasonableness of reading the Civil Rights Act to protect against discrimination on the basis of gender identity or sexual orientation, it might seem more reasonable when the justices already know that religious employers and organizations are going to be broadly exempt from this ruling.
So I definitely want to talk about some of those cases that you mentioned, the Bostock case, the Guadalupe case. Before getting to that, let's stay looking at the bigger picture for a little bit. And I want to pick up something that you mentioned towards the end of your comments about the court being seen as political. So let's take a look at the second half of the title for today's discussion, hyper-partisan era. On the one hand, how do you think that hyper-partisanship is affecting the court? And on the other hand, as a related question, how adequate are political labels in understanding the divisions within the court? We typically refer to them as conservatives or liberal justices. We talk about the conservative bloc, the liberal bloc. Are those terms accurate, or are there better ways to understand their disagreements?
Yeah, some people call them Trump judges or Obama judges, right? Well, so on partisanship, the premise of your question, you said the court, is it political or not? That can mean different things to different people. The court is a court of law. It's not supposed to be a political body, but its decisions have immense consequences for the political world. And also, the interpretation of law is necessarily bound up in at least some value judgments about the role of the court and the principles that inform the Constitution. Tocqueville said a long time ago, almost 200 years ago, in his sort of classic survey of American democracy, he said that judges are entrusted with immense political power. And the key is that they are very restrained in how they use that power. They don't jump into the arena of politics. That all sounds about right to me today. Now, though, I'd say that our political world is more polarized than the justices are. Actually, if you take the American public as a whole, it might not be more polarized. There's some great research on this by Mofi Arena and others on saying that, political activists are polarized, the American people aren't. Well, the political activists are much more polarized, or the politically engaged people are much more polarized than the court. In the court, you see broad unity in a lot of cases, including some of the most controversial cases that the court has decided. But it has to decide these cases in this, in the middle of this storm. And a great example of this was from the very beginning of this term. Before the court heard their first oral arguments of the year, there was this amazing, sort of astonishing brief filed in a case involving New York gun regulations. The brief was filed by a group of U.S. senators led by Senator Sheldon Whitehouse, where they said they just denounced the court. They said the court was broken. It needed to heal itself before it gets restructured, which was a thinly veiled threat about packing the court. And that the court should not weigh in on that case. It must be very hard to do your job as a judge in that environment. At the same time, though, the judges have life tenure and they know it. And that's the whole point. And Alexander Hamilton wrote about this in Federalist 78. So I don't worry about the court getting too political in the crass sense. And I also don't worry about them being sort of overpowered or pushed around by the political branches, although, as Hamilton recognized, that's always a threat. I think the challenge is that, and I promise I'll stop filibustering, I think the challenge is that this court, led by Chief Justice Roberts, seems inclined to do things in small bites more often than not. I mean, it's a mix, but in general, Chief Justice Roberts has always said from the start he wanted to sort of go for broad consensus, narrower opinions, and so on, which means that the court kind of nibbles at issues a lot of the time. And that leaves everybody unsatisfied, whether you're winning or losing a given case. Even the winners are dissatisfied because they're not getting bigger wins or more categorical wins that sort of clarify the law in one big sweep. And I'd say that sort of constant urgency around the court has a real important impact on the litigation that comes to it.
I think it's a good segue into another high-profile case of the term, which was the June medical case. It's a 5-4 decision that struck down a Louisiana law requiring doctors who perform abortions to have admitting privileges at a nearby hospital. So on the one hand, I'd be interested to hear your thoughts on the case itself, but kind of, again, continuing on the theme that you were just talking about there, what does it say about Chief Justice Roberts in particular and his overall tendency to, as some commentators worry about the legitimacy of the court, the perceived legitimacy of the court? Could you talk a little bit about those two components? And Adam, I think I'm having some trouble hearing you.
Oh, you know what? I hit my cough button and then I forgot to hit it again. Can you hear me now?
I can hear you now, yes.
So I was saying that, just by way of background, in American constitutional law, state regulations or federal regulations on abortion are judged by what the court called the undue burden standard. This comes from a case in the early 90s called Planned Parenthood versus Casey. I'll tell you, Justice Scalia used to love to lampoon this standard. Scalia, by the way, I always like to point out, was a former AEI scholar in the early 80s. I once saw him give a talk at the court where he said, the undue burden standard, all that means is that the justices hear oral arguments and then they go back into the conference room and they say, well, is this an undue burden or is it a due burden? And Scalia says, I think it's probably a due burden. Anyway, it's such a nebulous case. I mean, not such a nebulous standard. And so you get cases like this. There was a case a few years ago out of Texas called Whole Women's Health. It involved similar laws. Where the state passes laws or imposes regulations that require, say, abortion providers to have what we call admitting privileges so that they can be at a hospital, that the facilities are maintained and operated in certain ways. The advocates for these policies say that this is just the kind of normal safety regulations that we'd put on any medical facility. Critics of these policies say, no, this is backdoor regulation, backdoor prohibition of abortion. You're trying to just shut down as many abortion clinics as you can, which, by the way, is sort of it's interesting to see the left come out so full-throatedly against the effects of regulation on industry, but I digress. Anyway, a few years ago, the Supreme Court heard a case like this out of Texas and said that these regulations were an undue burden. Chief Justice Roberts was among the 4 dissenting justices. He said, no, these rules are totally justifiable. So when this new case came out of Louisiana involving similar rules, but of course every state is a little different, and so the circumstances, the impacts of the rules were a little different in Louisiana, at least Louisiana argued that they were. A lot of people thought, okay, the Supreme Court will just reverse its old precedent. There's a new 5-justice majority that seems much more comfortable with this kind of regulation of abortion. And not only did the court not sustain the statute, these rules, it struck them down, Chief Justice Roberts joined the majority this time. And he said in his opinion, he said, I think the last case was wrongly decided. I still think it's wrongly decided. But precedent matters, and this is not the right case to overturn that precedent or to overturn the underlying precedent of Planned Parenthood versus Casey. So simply as a matter of preserving precedent, we're going to, I'm going to allow this law to stand. Now, in sort of my long-winded answer, I lost the last part of the question there. And I think it's this. It's that I do think Chief Justice Roberts' focus on precedent, it is one of the ways that he is trying to deal with the political environment. It's fascinating. Set aside abortion, any case that involves questions of precedent. There was another case this year involving criminal juries. Anytime we start talking about precedent, it becomes a giant proxy war for Roe v. Wade and abortion rights. And I think Chief Justice Roberts has said, and not just this term in the past, but he's really living it out this year, that you overturn precedent at the end of a long process of raising questions about the precedent, finding ways to narrow or limit the precedent. Only after sort of a long process do you just outright overturn the precedent. And so Roberts here, even in a case where he thought the precedent was just flat out wrong, he said, we're gonna stick with this precedent. I'm working on an essay right now for one of the magazines on this fight about precedent, and it's bound up with the fight about textualism, which I see is popping up in the Q&A box.
Right.
I've been going back and reading sort of books and speeches by the justices of the mid-20th century, the Warren Court, that created so many of the current precedents, while sort of overturning the precedents that came before them. And it's really amazing how candid they were at the time. Some of the justices said, yes, we are overturning precedents, but our precedents won't be overturned because they're better. That's extremely and they were. I'm putting it very charitably. One of the justices, Arthur Goldberg, was extremely cynical about this, and you haven't seen that. I think one of the great things about this term is you've seen justices in a number of opinions really grapple in good faith with what it means to be precedent and how much weight to give a precedent. But that is one of those parts that's really bound up in the political atmosphere around the court.
Great, and I'll just mention for those of you tuning in, I see questions coming in the Q&A box. Definitely help us out and decide which ones you want to hear by using the upvote feature. Maybe one or two more questions on my end before turning over to Q&A. We mentioned the Bostock case, we mentioned the June medical case. Those were cases that were obviously dismaying to many social conservatives, but the term also included big wins on religious liberty cases that we talked about a little bit. There was the Guadalupe case on ministerial acceptance. There's the Little Sisters of the Poor case on the HHS contraception mandate. There was the Espinosa case on tuition assistance for religious schools. Can you talk a little bit more about maybe one of these cases, and more broadly, what changed during this term about religious liberty jurisprudence in your mind?
I don't think a lot changed on religious liberty jurisprudence, to be honest. I think that this was an area where things really stayed steady. The Guadalupe, Our Lady of Guadalupe case about the ministerial exception to employment laws, that was a pretty straightforward follow-up to a case from just a couple of years ago. The name is suddenly escaping me. I'm terrible with case names. I always wind up in my classes saying the case about this or the case about that. But that was the court's reaffirmance of the ministerial exception as applying equally to teachers at religious schools was not surprising. The affirmance of the Trump administration's exemptions for the Little Sisters of the Poor under the Affordable Care Act, that was a straightforward application or continuation of the previous cases we'd seen involving the collision of the Religious Freedom Restoration Act and other statutes. There's a big case out of Espinosa where the Supreme Court held that it's unconstitutional for a state to just categorically bar generally available subsidies from going to religious organizations. Here it was a student who wanted to use a education voucher program at a religious school. It wasn't that he was going to go and study religion per se. That was the issue in a much earlier case called Locke v. Davey. It was just he wanted to go to school at a religious school. And this was the law prohibiting the use of state funds for that purpose owed to a thing called it's often called the Blaine Amendment, a series of state constitutional amendments prohibiting government funds from going to religious schools. And the court really sweepingly struck down that Montana implementation of the kind of Blaine principle. That could have real broad effects in other states. It's the second recent Blaine Amendment case we've had. I think it was pretty broad. What it means is that we're having, like I said earlier, we have these sort of two tracks of cases. We have cases that affirm these, often broad regulatory programs like the Affordable Care Act's contraceptive mandate or what have you. And then at the same time, we have carve-outs for religion. I'm all in favor of religious liberty, to say the least. But stepping back and as a political observer, there's something a little ominous about this constant collision between religious liberty and the administrative state that I think is going to continue to be a defining feature of American constitutional law. And I'm all in favor, just again, to say the least, all in favor of protecting religious liberty. It's right there in the Constitution, and it's there in the Religious Freedom Restoration Act. But I worry that the debates are taking on, the religious liberty is taking on a partisan valence, which would be very, very dangerous for American constitutional politics.
So I have other questions, but I want to turn over to our audiences now. So thank you for the questions that you submitted, folks. Let's start with one from Matt Aldridge. He asks, while the court itself might not be as partisan as commentators make it out to be, the confirmation process has become intensely politicized. Do you think that in our political environment, a future precedence nominee for SCOTUS could be confirmed when the Senate is controlled by an opposing party?
That's a great question. When I was in law school in 2004, I wrote a law review article. This is back when Bush was the president, Democrats held the Senate. Right. I was a big fan of Bush's judicial appointments. But I wrote my third-year paper in law school saying that the Senate does not have a constitutional duty. The Senate doesn't have a constitutional duty to vote on a judicial nomination. That the Senate can just ignore the nomination if it wants. There was a student note, so it was ignored for about a decade and a half until about 5 seconds after Justice Scalia passed away. I came into my office the next day, or sorry, 2 days later, and like my office voicemail was full of calls from questions from Capitol Hill saying, "Hey, we saw your paper. Please explain to us, is it right we don't have to vote on Obama's nominee?" I think that was correct. I don't think the Constitution does require the Senate to vote. And McConnell has proven it as a matter of fact that they won't vote if they don't want to. And I was in favor of that. But the question, I think, is very well put. I'd say that we've opened the door to a scenario where the Senate might simply refuse to vote for the opposing president's nominees. But these issues are always political, and it's really going to depend on who the middle senators are, right? Could there be a strong 51 senator, majority to block a vote for a period of years? Maybe it could happen. We haven't seen a majority like that yet. I don't think Susan Collins or others would have done it for more than a year. And also, I think if that were ever to be a real threat, it would have an impact on who the president is nominating, right? You might actually see that because in the end, like I say in my paper, the president needs to convince the Senate to come his way. The framers actually debated the opposite proposal. They debated a proposal where the president would appoint unless the Senate could muster a veto. But they placed the burden of proof, so to speak, on the president's side. He needs to convince the Senate. And so I think in ordinary politics, the most likely outcome would be the president would find a moderate justice if he really needed one on, right? He'd find a moderate, say it's President Biden against Senator McConnell in a Republican majority. You'd look for somebody like Sri Srinivasan of the DC Circuit, or another sort of moderate Obama-appointed lower court judge who would manage to break off some support from the Republican majority.
There's a related question from Jonathan Chu that asks, in 2008, Senate Majority Leader McConnell said the judicial appointments were his top priority as majority leader. How do we get to the point where the Senate's most important, quote unquote, legislation are the judges it confirms, and how do we get to a situation where that can be fixed?
Yeah, you've put your finger on a huge problem, and one that I've written about a little bit. Because while I'm a big fan of judicial appointments, and I'm a big fan of a lot of the judges who have been appointed, right? I'm not saying I wish that President Trump and Senate Majority Leader McConnell had confirmed fewer judges. There is a real cost to this in terms of legislation, and also, by the way, in terms of executive branch appointments. McConnell gave an interview where he said, somebody asked him about how many judges they were confirming and how few executive branch officials. And McConnell said, listen, this is not a hard question. If I am choosing to dedicate Senate floor time, which is a scarce resource, to either a life-term judge or some deputy secretary of this or that who's only going to be there for a year and a half, it's not a hard call. And I get the calculus, but it's really no way to run the country because we do need legislation. I think the absence of Congress from day-to-day lawmaking has been catastrophic for our constitutional system. And also, the Senate's absence from administration is a huge problem. This is one of my major research interests. I wrote a little bit about this on the eve of the Senate impeachment trial for National Review, where I said the Senate has gotten so far away from what it was intended to be, which was a legislative body, yes, and that's important, but also a body that really invests itself deeply in the work of administration because it has important roles to play, both in legislation and appropriations, but also the appointment of executive branch officers, the review of treaties, and so on. That the Senate sort of ceding all that territory to the president, I think, has really skewed the machinery of our federal government, and that the Senate needs to invest itself much more. But to actually answer your question, how do we get back to that? I don't know. I think until the Supreme Court plays less of a role in policymaking, it's always going to be, those seats are going to be extremely valuable. I am amenable to sort of term limits for justices. I'm open-minded about this in a way because it would help take some of the pressure off of each individual judicial vacancy.
So Trenton Curtis has an interesting question. He asks, with regard to the Boston case and Justice Gorsuch's reasoning, what degree does Justice Gorsuch reasoning align itself with a textualist interpretation that many consider him to be a champion of?
Yeah, this is another piece I'm racing to write these days. Justice Gorsuch's opinion, it was a textualist opinion, but it was a kind of textualism, right? It was not, in fact, he specifically says, we're not going to worry too much about how the authors of this law thought it would be applied. We're focused on the dictionary meaning of the words as they wrote them. There are very subtle distinctions between the conservative justices on how they go about determining what the original meaning of a legal provision is and how they apply it. That's not a new debate. Justice Thomas and Scalia often disagreed, but they usually wound up in the same place at the end of the day. But as arguments before the court become more and more nuanced, and as progressives come up with more and more sort of textualist arguments for their own positions, you're going to see debates like this. So to answer the question, I do think Gorsuch's opinion was textualist of a sort. I do think it gave short shrift to how the framers of the Civil Rights Act thought that provision would operate as a whole, what problems they were trying to solve, and what problems they thought they weren't touching. It's sort of a holistic analysis. I will say that conservative textualists always said we shouldn't think about legislative history. We should just think about what the words of the statute. And that makes a lot of sense. But I do think that there comes a point where focusing on dictionary definitions of statutory terms becomes a little bit too abstracted from the actual statute that was passed by a given people for a given people. And so I think Justice Alito got the better of the argument when he said we need to be a little bit more realistic about what Congress thought it was doing and what Congress was attempting to do in the Civil Rights Act. So again, I think Gorsuch's opinion was textualist, but it was textualism of a sort. And I think we're going to have a lot more occasions to sort of grapple with these sort of subtle nuances and fault lines within the broad sort of group of textualist or originalist justices. And the question of precedent becomes huge then too, if I can just jump to the next question from William Blanks. These debates about textualism are inextricably bound up with debates about precedent. Because if nothing else, debates about precedent, they sort of presume certain things about a decision being right or wrong, an interpretation being right or wrong. The more confident that you are that your textual interpretive methodology can produce right or wrong answers, the less patient you'll be with precedents that don't line up with the outcome that you think is the right reading of the law. Justice Thomas has probably gone the furthest in saying that precedent should be given little weight. He had a great opinion many years ago where he wanted to overturn a precedent from, I think, the first decade of the 1800s. And he said, just because we've been doing it wrong for 200 years isn't a good reason to keep doing it wrong. And there's some real appeal to that argument. But I do think that the precedent plays an important role. And the reason why I'm writing about this subject is that I don't know the answer. There's no sort of principled line between where you go with your own view of the original meaning and where you go with precedent, where you go with others' view of original meaning. And this is one of the most difficult challenges that the court has to grapple with today, especially when, like I said, anytime they breathe the word precedent, everybody is going to assume they're saying Roe v. Wade. And it's just such a powder keg inside and outside of the court.
So we're running out of time, but I want to ask, and I'll paraphrase Scott Randall's question, which is about the election. I think a lot of people that supported President Trump did so because of his judicial appointments, especially in light of the Bostock case. Is that argument still persuasive going into 2020?
My friend Pete Wehner wrote a good piece saying that the Bostock opinion really proves that the bargain that some conservatives made with President Trump on account of the judicial nominations just wasn't worth it. I respect Pete. And by the way, just for the record, I was a very skeptical Never Trump Republican and remain a very skeptical Never Trump Republican. So I never sort of made that deal. But I think Pete gives that deal short shrift. I think that when you look to not just Gorsuch, but Kavanaugh and all of the really amazing judges who have been appointed, it's impossible to say that this isn't an extremely important and impressive legacy of Trump's administration so far. And so, no, I think that the Bostock case, as disappointing as it may have been to the conservatives who voted for Trump because of the judges, I'd say that President Trump's judges overall, including Gorsuch, have been just really impressive. And by the way, Gorsuch's opinion in Bostock will be cited and invoked over and over again by Gorsuch when he is applying his textualism in cases that lead to outcomes that progressives don't like as nearly as much as Bostock. He's always going to be able to point back to the Bostock decision to show that his textualism is not just sort of clever cover for political outcomes. And it's good for justices, I think, to apply their methodology even when it comes to the outcome that political observers like me might not like, because I think it builds up their credibility in important ways for the long run.
So I think that's all the time that we have. But Adam, thank you so much for joining us.
Oh, it's my pleasure. Thanks, everybody.
And thank you all for tuning in. We hope that you can join us again next Wednesday, same time, 5:30 Eastern Time. We'll be speaking with AEI's Catherine Zimmerman on contemporary counterterrorism. So keep an eye on our inbox for that invitation. Two more things on my end. I'll mention that we have the Summer Speaker Series t-shirt giveaway. So if you attend 3 or more Summer Speaker Series, you'll be automatically entered into that. If you're here today, join us next week and the week after that, and you'll be entered for your chance to win. And last, if you have friends in college who are interested in these types of conversations, encourage them to sign up for the Student Network to receive invitations to the Summer Speaker Series and to learn about different opportunities that AEI has for students. So thank you all again for joining, and we'll see you next week.